Hi there. So I've been following the Masterpiece Cakeshop case very closely. If you look on YouTube, there's a video you can find of me debating Bob Levy from the Cato Institute as to how that's going to come out before the decision. Now that the decision has happened, a few people have asked me to publish something that explains the ruling because it's very challenging to understand. And I'm going to do that in the form of a video because it's a lot faster than making a written essay. For those of you who don't feel like watching the entire video, here's the spoiler. The end result is that though the Supreme Court had the chance to change the law, they ultimately decided not to do it. So in the end result is still that businesses are not allowed to discriminate, even if the business is owned by somebody whose religious beliefs either permit that or require that. And the Supreme Court also declined to create an exception to anti-discrimination laws where someone's engaged in a business that involves some level of artistic expression. All they did was throw a line to this one particular baker based on what they felt was that he didn't get the benefit of an impartial tribunal. I'll discuss that in detail in a minute, but that's not really an argument that's going to work for anybody else more than once. It really is just this one guy who gets to use that argument. For everybody else, the law is not changed. So if any blogs or partisan news outlets told you that the Supreme Court said it's okay for businesses to discriminate now as long as the business owner's religion says that it's against their religion to comply with anti-discrimination laws, don't listen to them. That's not what happened. They either don't know what they're talking about but think they do. There's a lot of that in the country right now. Or they know perfectly well that they're wrong and they're trying to trick you. There's a lot of that in the country right now too. So that's the gist of it. Keep watching if you want to get your hands all dirty with the details, but that's the gist of what I'm about to explain. The Masterpiece Cakeshop decision is very challenging to understand for somebody, even with somebody with legal training, and for somebody who's not a lawyer, it's ridiculously difficult to digest. And the press did not do a very good job of explaining it. Most of the coverage just called it a victory for the bakery, and then they had this footnote that it was decided on very narrow grounds without explaining what that means. And we've already seen a lot of misunderstandings. There's gay rights advocates that were lamenting the loss, even though it was really a win for them. You also saw the anti-gay crowd declaring victory, even though it was actually a loss for them. And there's even been some knuckleheads that own businesses and put up signs that said, we don't serve gay people now because it's against our religion, believing wrongly that the Supreme Court said that they can do that now. They did not. That's not what happened. And I'm going to explain what the Supreme Court said, what they didn't say, and what happens now. So let me start with some basic stuff, how the Supreme Court works. It is the court of last resort. So a requirement for them to take your case is that no other court can take it. You've already exhausted all the other courts that had jurisdiction over your case, and you're down to just them. That's a requirement. It takes 4 justices to decide to take a case, 5 out of 9 to decide it. There's 9 justices. Um, and they only take about 75 to 100 cases a year. So that's for the whole country. It's less than 1% of people who ask for their case to be taken. So it's, they try to pick cases that are going to resolve a conflict among the courts, or cases that are going to be of great public importance. They look for cases like that. And it looks like they took this one because they wanted to re-examine a couple of prior precedents, which they decided not to overturn. Now, when they rule on the result of a case. They supply reasoning along with that. Sometimes they supply pages and pages and pages of reasoning. The reasoning isn't really the ruling. The ruling is the outcome. So if it takes 5 out of 9 to agree on an outcome, sometimes all you get 5 out of 9 that agree on the outcome, and they have 5 different reasons for how they got there. And that just makes that precedent very hard to apply in the future, because in future cases where that comes up again, we're not really sure whose opinion to follow. But um, what can happen is that they all agree on the result for different reasons. This one was not a 5-4 like a lot of decisions are these days. This one was a 7-2 decision. Although the reasoning of the 7 isn't exactly all the same, and I'm going to explain each justice's opinion. But this was a 7-2 decision where 7 out of 9 justices felt like the order from the Colorado Civil Rights Commission should be reversed. Two of them held that it should have been affirmed, but they were the dissenters. Um, Let me give a little bit of a legal background at what was at stake in the Masterpiece Cakeshop case. First off, I need to explain what public accommodations laws are because most people don't call them that, and the phrase civil rights laws is broad and encompasses a lot more besides just that. Public accommodations laws are laws that require that a business owner who is a public accommodation, and public accommodation generally means restaurants and hotels, but any business really that's open to the public, where any member of the public can expect to come in and be served, is generally a public accommodation. I'm oversimplifying it just a little bit, but that's what that means. And public accommodations laws were laws that forbade somebody who owned a public accommodation from discriminating against customers based on their race, their religion, their color, their national origin, and some other um, different characteristics that were added to the list over time. That list is called protected classes. So uh, religious beliefs, color, race, disabilities, sexual orientation is a recent addition. All of these kind of are the list of protected classes. So a public accommodations law isn't triggered until you have a public accommodation and you have a member of a protected class that the owner of the public accommodation is not allowed to discriminate against. Those laws were passed because we needed them. Most people think about the Woolworth's lunch counter protests in 1964. For those of you who don't know, Woolworth's was it was a drugstore kind of department store. They're not really around anymore in the United States. I think the last one closed in the 1990s, but they were department store kind of drugstores. They sold food. They also sold clothes and school uniforms and school supplies and pots and pans and whatnot. And in the back, there was a counter where they had waitresses and cooks, and they would make nothing really elaborate, but sandwiches, pie, coffee. People would come and have lunch there. And the counter was all the way up until 1964 for white people only. Everybody could shop at the store. Anybody could buy the products in the store, and they could buy the food in the store and eat it outside. They could even come to the back door and order food. But African Americans were not allowed to sit at the lunch counter and order lunch there. And in Greensboro, North Carolina, some African American students decided to sit at the lunch counter and ask to be served. It started a movement throughout the country. African Americans began to sit at lunch counters in other states, and then white people would come and harass them. Some of these turned very violent, and it kind of woke up the nation to what was going on. It brought a lot of attention to the indignity of being denied service at the lunch counter, and it made the country have to kind of reckon with whether or not there's any justifiable reason to continue this practice. Woolworths ultimately caved to public pressure, and they reversed their own policy and integrated their lunch counters, but the conversation had already been started, and it culminated in Congress passing the Civil Rights Act of 1964, which for the very first time created a federal law that forbade businesses from discriminating against people based on their membership in a protected class. Before that, and I have these with me, this is called the Green Book. This was published from 1938 until 1964, where the Civil Rights Act of 1964 kind of rendered it obsolete. But this was a book that was published. It was often called the Green Book. The Negro Motorist Green Book was its official title, and this was just a listing that was published every year of restaurants and hotels and motels that would serve African Americans. And if you were traveling outside of your hometown during that time period, the 1930s through 1964, you had better take this book with you because it could be hundreds of miles in between hotels that would allow you to stay there, and you might encounter violence if you tried to eat at a restaurant where you were not welcome. And so anybody that was African American that was traveling during this time period had to take this book with them and know where they could and couldn't go. And you know, if you look at Tampa, for instance, there was only one hotel and three restaurants. But it could be hundreds of miles before the next one, so you really had to plan your trip around this. This was no way to live, and the 1964 Civil Rights Act did away with that. Now, Colorado was way ahead of the game. Colorado passed its first public accommodations law in the 1800s. So they were about 100 years ahead of the country in passing the Colorado Anti-Discrimination Act, which, like the 1964 Civil Rights Act, forbade businesses from discriminating against customers based on their membership in a particular class. I'm just going to pull up the text of the 1964 Civil Rights Act. If you take a look at the list of protected classes here, it was very narrow at this time. It was just race, color, religion, or national origin. Those were the only four protected classes against whom you could not discriminate. So you could in 1964 you could still discriminate against people with disabilities. You could say we don't serve people in wheelchairs, and that was legal in 1964. It's no longer legal now, but it was at the time. You could discriminate against sexual orientation in 1964. These were the four original protected classes. I should note, too, that when we're talking about public accommodations laws, it is perfectly legal to discriminate against somebody who's based on something other than their membership in a protected class. So if you don't like lawyers, and a lot of people don't, there's nothing illegal about putting up a sign that says, this restaurant doesn't serve lawyers. Lawyers are not a protected class. A lot of the rhetoric discussing this case was, in my opinion, either misinformed or deliberately misleading, because there were these examples that were being floated out that just were not, apples and oranges comparisons. They just were not something that would have triggered up public accommodations laws. For instance, I heard the argument many times, well, could Nazis go into a Jewish bakery and demand that they bake a swastika-shaped cake? And the answer is no, they couldn't, because Nazis are not a protected class. Same thing for the example of, well, could a Klansman go into a Jewish tailor and ask for their Klan robe to be sewn up? No, because Klansmen are not a protected class. There's also, people who were not public accommodations. So you would hear arguments like, what about lawyers? Does the lawyer have to take every case that comes in? Does the ACLU have to take every single case? No, lawyers are not public accommodations. Lawyers are by appointment only, and they only have to take the cases that they want. Very few lawyers that I know of have a storefront at the mall where you can just walk, anybody in the public can expect to walk in and receive legal services. Lawyers are by appointment only, and they will take your case if they want to. So when you're talking about public accommodations laws, unless you're talking about a public accommodation, a business that's open to the general public where anybody can walk in and expect to be served, and unless you're talking about a protected class as defined in whatever statute that you're talking about, then we're not really implicating public accommodations laws. And we should be very clear about that, because a lot of the public dialogue just glossed over that and didn't seem to comprehend that distinction. There's also, one argument that you see in this case that I'm going to discuss in a little bit, is the argument that some public accommodations involve artistic expression that's protected by the First Amendment. Shouldn't they be able to discriminate and withhold their speech, their artistic expression, whenever they feel like it? To kind of look again at the 1964 Civil Rights Act, it defines public accommodations as inns, hotels, motels, other establishments, restaurants, cafeterias, lunch houses. But notice in subsection 3, in section 201, subsection A3, it states any motion picture house, so that's a movie theater, and then it says theater separately from motion picture house. So I assume they're not talking about a movie theater, they're talking about a theater where they show plays. Concert halls. Theaters and concert halls are venues for artistic expression, and the 1964 Civil Rights Act still labeled these public accommodations. So a singer, even though they're singing in a theater, and that is artistic expression, that is speech, the 1964 Civil Rights Act still required the theater to sell tickets to members of protected classes, even if the singer would rather not sing for them. You can imagine that in 1964, when that statute was passed, there were people who did not like it, especially in the South, and they immediately began challenging the statute and trying to find ways around it. One of the first challenges was a case called Heart of Atlanta, which questioned whether or not Congress even had the authority to pass that statute. And the U.S. Supreme Court held that yes, under the Commerce Clause of the United States Constitution, the Congress does have the power to pass that statute. That's an entirely different lecture I'll do on a different day, but just know that the first challenge was, did Congress even have the power to pass the statute? Maybe the whole thing is invalid. The Supreme Court said it's valid, and they did have the power to pass it. The next challenge to it was a case called Newman versus Piggy Park, and that's what was at stake in the Masterpiece Cakeshop case. The Newman versus Piggy Park decision involved a barbecue, and the owner of the barbecue did not want to integrate his barbecue. And so he argued that it was his deeply held religious belief that African Americans and white people should not eat together, and therefore it violated his religious freedom to require him to serve black customers. That he actually went to the Supreme Court with that argument. Now he couldn't really point to anything in the Bible that backed that up, so he kind of made something up, in my opinion, and he argued that, well, God put the white people in Europe and the black people in Africa and the Asian people in Asia, and he must have wanted them separate then if he did that, so I want to keep them separate in my barbecue establishment. That was his ridiculous argument. And he got all the way to the U.S. Supreme Court with that, and they rejected it and said, you can't violate a constitutionally valid law of general applicability that all of us have to obey just because you have adopted religious beliefs that require you to break that law. You do have a right of free exercise of your religion in the United States, but that right does not go so far as to allow you to violate whatever laws you like, as long as your religious beliefs say that it's okay to violate those laws. So the Newman versus Piggy Park case held 50 years ago that you don't get to violate public accommodations laws just because your religion either permits you to do that or requires you to do that. That's what was at stake in the Masterpiece Cakeshop case, and that's why a lot of civil rights attorneys were a little bit scared that, oh my God, is this going to fly? Are they actually going to overturn the decision in Newman versus Piggy Park? If they do, that's going to create a loophole big enough for anyone to drive a truck through. And businesses are once again going to be able to discriminate against members of protected classes. All they have to do is utter the magic words that their religions require them to do that. So that did not happen, but that was what we were all afraid would happen, or that almost happened, to be perfectly frank. Another case I want to talk about, it's not really about public accommodations laws, but it's very related, is a case called United States versus O'Brien. And in United States versus O'Brien involved someone being prosecuted for burning his draft card. There was a statute in effect at the time that every man between 18 and 35 had to have his draft card with certain information on it, and he had to keep that on his person at all time. People who were opposed to the Vietnam War often would burn them in an act of public protest to the Vietnam War. And this Mr. O'Brien was prosecuted for doing exactly that. And he argued that under the First Amendment, he has a right to freedom of speech, and he was trying to say something by burning that card, and therefore the government shouldn't be able to prosecute him for engaging in what was really protected free speech activity. When that one got to the Supreme Court, they rejected that argument outright, and they held that when a constitutionally valid statute that has a valid reason to exist, and the draft card statute they held did have a valid reason to exist, when Congress passes a statute, the fact that you are trying to say something with your conduct, the fact that the act of breaking that law in your mind is expressing something, does not give you a green light to go ahead and break whatever laws you like, as long as you're expressing something by doing so. So O'Brien and Piggy Park both held that when a law is constitutionally valid, when it applies to everyone, you don't get a license to break that law by having religious beliefs that require you to break it, or by taking the position that you were expressing yourself by breaking that law, and therefore you're allowed to do that. So with all of that as a backdrop, that was what was at stake in the Masterpiece Cakeshop case. Was the bakery raised two arguments. One of them was that they should be allowed to discriminate against homosexuals because their religion requires them to do it. And the other argument was baking a cake is some kind of an act of speech. It is artistic expression, and when artistic expression is involved, the government can't compel speech, and they'd be compelling speech by requiring this bakery to sell a wedding cake to a gay couple, and therefore that's not constitutional. Those were the two arguments. They lost on both of those arguments. They won on really kind of a throwaway argument that I don't even know that they meant to make, and I'm going to get to that in a minute. But let's talk about what happened in the Masterpiece Cakeshop case. There were Mr. Craig and Mr. Mullins. They were engaged to be married. They were at the time gay marriage was not legal in Colorado, but it was legal in some states. Massachusetts was one of them. So Mr. Craig and Mr. Mullins were going to go to Massachusetts, get married there, return to Colorado, and have a wedding reception. So this wasn't even really a wedding cake to be used at a wedding proper. It was a wedding cake to be used at a wedding reception a couple of weeks after the actual wedding itself. They went into the Masterpiece Cakeshop. One of them brought their mother with them, and they told the owner, Mr. Jack Phillips, that they wanted to purchase a wedding cake. Now his response was a little bit bizarre. He said, I can't sell you a wedding cake because my religion opposes gay marriage, but I can sell you shower cakes or birthday cakes or cupcakes, which is to me a very strange response. It would be like going into a barber shop and saying you'd like your hair cut, and they say, we don't cut the hair of people like you, but would you like a foot massage? I mean, it's not what you asked for, so why would he say that? I suspect that he had been coached to say that by an attorney who knew that this case is going to come. Everybody's talking about this hypothetical. Would a Christian baker have to bake a wedding cake for a gay couple, even if he'd rather not? And my suspicion is that he had been told, if you say that, that enables you to argue in court later that I didn't refuse to serve them. I just wouldn't serve them this. I would serve them that, though. I didn't tell them that there's no service at all for you. I just told them that I'll sell you anything except for that, which is, to me, kind of like Woolworths saying, well, you can buy any food in the store and go outside and eat it. You just can't sit at the lunch counter. That's not a satisfactory response, but that was the argument that he took. Also, so they left the store. By all accounts, the conversation was over in less than 1 minute. Maybe even less than 30 seconds. They didn't talk for very long. Significantly, they never discussed what the cake would look like. They never discussed whether the cake would have any writing on it. That just never came up. It was, if you're gay and you're going to use the cake for a gay wedding, I won't sell you any cake at all for that purpose, but I'll sell you a birthday cake or a shower cake, he said. Also significantly, or the court thought significantly, some of the justices thought significantly, the next day the mother called back and said, explain to me, please, why you wouldn't sell a cake to my son. And the baker said, well, I wouldn't sell the cake to you either. I wouldn't sell the cake to anybody. I will not sell anybody a cake that I know is going to be used in a gay wedding. So it's not that I didn't refuse to sell it to them because they're gay. I also wouldn't sell it to you, even though you're straight. So the argument was, he had been coached, I think, to position himself to make the arguments that he did make. Anyways, Mr. Craig and Mr. Mullins filed a complaint with the Colorado Civil Rights Division. The Colorado Civil Rights Commission, which then referred the matter to the Colorado Civil Rights Division for a probable cause determination. The division investigated. They found that there was probable cause, that the Colorado Anti-Discrimination Act was violated. I guess I should put up the Colorado Anti-Discrimination Act. It's very similarly worded to the 1964 Civil Rights Act. This is not the original statute that was passed in the 1800s. It's been added to. But if you look at subsection 2A, sexual orientation, marital status were added to the list of protected classes. So under the Colorado Anti-Discrimination Act, race, creed, color, sex, sexual orientation, marital status are all treated equally. They are all protected classes. So You could not refuse to serve a gay person under any circumstance that you would not be allowed to refuse to serve somebody because of their race. The statute treats them equally. So, anyways, he went. They argued that uh, the Colorado Anti-Discrimination Act forbid this bakery from refusing to serve them. The Colorado Civil Rights Division found probable cause, referred it back to the commission. The commission then sent the case to an administrative law judge. And the administrative law judge is where the bakery made the argument that its religious beliefs were being implicated and that even though it would violate the Colorado Anti-Discrimination Act for somebody else under the exact same circumstances to refuse to sell a wedding cake to Mr. Craig and Mr. Mullins, this particular bakery ought to be able to do that because its owner, Jack Phillips, is a deeply religious man and really believes that gay marriage is against his religion and therefore can't have any participation in the ceremony. That was the argument that he made. Well, I want to examine his argument for its merits, which is something the court did not do, and something that I didn't really even hear very much of in the public dialogue, which is challenging the sincerity of Mr. Phillips's religious beliefs. You are allowed to inquire, and the courts are allowed to inquire into the sincerity of religious beliefs because if they weren't, of course, anybody could claim that their religious beliefs were whatever they needed to be for the particular circumstance. So the courts do look into the sincerity of that. This goes all the way back to the conscientious objector cases where people tried to get out of the draft by arguing that it was against their religion. The courts would look into the sincerity of their religious beliefs. No one really did that with Mr. Phillips, but I'm gonna do it. Let's do it because I want to point something out that I think is very significant, and I never heard very many other people talk about this. This is a Bible verse. This is 1 Corinthians chapter 7. It's two verses, verses 10 and 11. And this verse says, "A wife must not separate from her husband, but if she does, she must remain unmarried or else be reconciled to her husband, and a husband must not divorce his wife." So this is pretty straight talk. There's not much room for interpretation as to what these Bible verses mean. It very clearly says that if a woman is divorced, she can't remarry. Unless it's her original husband. So anybody who is a divorced woman who's on her second marriage, the Bible says that's not allowed. Now I want to compare this to an affidavit that Mr. Phillips filed in front of the administrative law judge in arguing that he shouldn't have to comply with the Colorado Anti-Discrimination Act to the extent that it violates his religion. He talked about this, and he mentions in the affidavit that if a client wanted a cake for a polygamous wedding or a wedding for a reception for a man or a woman waiting for their divorce to be finalized but still actually married to other people, we would decline to design and create a wedding cakes for such occasions. So he kind of admits in this affidavit that 1 Corinthians chapter 7 verses 10 and 11 notwithstanding, he'll meet his sinful customers halfway if he's got a couple of divorcees getting ready for their second marriage. He'll still bake them a cake as long as he's satisfied that the divorces were final in the first marriage. So he's meeting them halfway and doing something that's not really allowed, or participating in a ceremony and that the Bible doesn't really sanction, because I suspect you're going to have a really hard time making a living as a wedding cake baker if you're not going to bake any cakes for people who have been divorced. That having been said, then he turns in his affidavit to another Bible verse. This is Mark chapter 10, verses 6 through 9. This verse says, and I'm reading it verbatim, "From the beginning of creation, God made them male and female. For this reason, a man will leave his father and mother and become united with his wife, and the two will become one flesh. So they are no longer two, but one. Therefore, what God has joined together, let no man separate." You've probably heard these verses before. They're often read out loud at weddings. And, to me, there's nothing in this verse that says anything about gay people or that they're not allowed to get married. This verse seems pretty straightforward to me that it's actually just telling you what happens after the wedding, not who's allowed to get married. But In Mr. Phillips's affidavit that he filed with the administrative law judge, he says that he believes that this is a quote from Jesus Christ, which shows unequivocally that in his own words, he regards marriage as between a man and a woman and anything else is sinful. The verse doesn't really say that, but his affidavit says that he believes that that's what Jesus meant to say, and therefore he is not allowed to deviate from that one, even though he's perfectly comfortable with deviating from 1 Corinthians. So all of that having been said, no one ever talked about that. But I have a hard time with the sincerity of his religious beliefs. I question if he really means what he says any more than the owner of the barbecue in the Newman versus Piggy Park case really believed that his religious beliefs forbade serving African American customers. I suspect he just didn't want to serve African American customers and made up a religious basis for that because he knew that the courts would afford him a little bit more weight to his beliefs if he said that they were religious. And I question whether Mr. Phillips did the exact same thing. But that having been said, that's just something that I've come up with. I haven't really heard, the courts certainly didn't look at that, and I haven't even heard much of the public dialogue talk about that. The administrative law judge ultimately resolved the case against Mr. Phillips and based the opinion heavily on a different decision I haven't mentioned yet. This is a U.S. Supreme Court case called Employment Division of the Department of Human Resources of Oregon versus Smith. In that case, a couple of gentlemen, they were Native Americans, they applied for a job, they took a drug test, they failed because they had ingested peyote, which is a hallucinogen, and they argued that they were a member of a Native American religion that required them to ingest peyote. And by not giving them a government job for failing the drug test for having taken this peyote, that the government was discriminating against their religious beliefs, which required them to take it. And therefore, the First Amendment's protection for the free exercise of religion should save them and require the state of Oregon to give them this job that they were applying for. The U.S. Supreme Court rejected that argument, again, kind of similar to the Piggy Park rationale, by saying this is a law of general applicability, it's constitutionally valid, nobody's allowed to ingest peyote, and by adopting religious beliefs that require you to break a law doesn't give you the license to break it. So the administrative law judge relied on the Smith case. Piggy Park would have been a better case to rely on, but the judge wasn't wrong to rely on Smith for the general proposition that if your religion requires you to break the law, that doesn't mean that we're violating your constitutional right to freedom of religion by enforcing that law when you break it. So the administrative law judge sent the case back to the Colorado Civil Rights Division with the opinion that the law was in fact broken and this constitutional objection is not valid. So the Colorado Civil Rights Commission issued an order, and they required a few things. One of them was that the bakery had to cease and desist from discriminating against gay people. And by that, it meant that they had to sell gay people anything that they would sell to a heterosexual couple. Let me talk about what that means and what that doesn't mean, because again, people can get confused. The order did not require them, the bakery, to do anything that they wouldn't otherwise do. So the Colorado Anti-Discrimination Act does not mean that Mr. Craig and Mr. Mullins could have walked into a McDonald's and demanded that McDonald's bake them a wedding cake, because McDonald's does not sell wedding cakes to anybody. But if it's a bakery that sells wedding cakes and they sell wedding cakes to straight couples, they have to sell them to gay couples too. That was the ruling. It also required some training of the staff, some changes to company policy, and quarterly reporting of patrons that were denied service with the reasons that they were denied service, also reportings of any remedial actions that were taken. So it was a pretty comprehensive order that required the bakery to do a lot of things to correct their past practices of discriminating against gay customers. It must have felt to Mr. Phillips like the tyrannical hand of the government had reached into his business and told him how he had to operate it. So he appealed the decision to the Colorado Supreme Court, or I'm sorry, the Colorado Court of Appeals, which affirmed the decision, and then he petitioned to the Colorado Supreme Court, which declined to hear his case. That left him with no other court that had jurisdiction to hear his case except the U.S. Supreme Court, And as I mentioned, it's a court of last resort. So the Colorado Supreme Court declining to take his case was the last thing that needed to happen for the U.S. Supreme Court to have jurisdiction to take it. So they did take the case, and the bakery raised two arguments. One of them was, this is compelled speech. Mr. Phillips is an artist. When he makes these cakes, he's not just preparing food for people to eat, he's preparing this work of art. And by requiring him through the Colorado Anti-Discrimination Act to use his artistic abilities to give a cake to this couple, then this is compelled speech and it violates his freedom of speech. That was one of his arguments. The other argument was that he's a religious man, that it violates his religious beliefs to have anything at all to do with a gay wedding, and therefore requiring him to do that violates his right of free exercise of religion. So teeing all of that up, that's what was at stake in the Masterpiece Cakeshop case. Was, is this going to work? Is he going to be able to argue that he doesn't have to comply with this law for either of these two reasons? And a lot of lawyers like me were concerned that if the Supreme Court answers yes on either of those bases, you're going to see a whole lot more discrimination. Businesses that want to discriminate are always going to be able to find a way to fit within one or the other of those loopholes. It didn't happen, and let me talk about what the Supreme Court ultimately did decide. Justice Kennedy wrote the majority opinion. Like I said, you only need 5 justices. He had all 7, I'm sorry, 6 of the 7 agreed with his opinion that was written by Kennedy, but it was joined by Justice Roberts, Justice Breyer, Justice Alito, Justice Kagan, who was a surprise, I'll talk to her in a minute, and Justice Gorsuch. He didn't really answer the key questions except to say that he did affirm, and I'm going to put up an actual screenshot from the opinion. It says right here, the First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach their principles that are so fulfilling and so central to their lives and faiths. Nevertheless, while those religious and philosophical objections are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. And you see there they cite the Newman versus Piggy Park decision. So to be perfectly clear, Justice Kennedy and the other 5 justices that I listed there all agreed that Piggy Park is still the law. Having a religious belief that requires you to break the law doesn't mean that you get to go ahead and break it. So they touched that question. He talked a little bit about the free speech argument, but didn't really rule on it. What he ultimately did, and was joined by by 5 other justices, was he held that the Colorado Civil Rights Commission was hostile to Mr. Phillips's religious beliefs, and so therefore the whole thing is tainted. Whatever happened after that is tainted, and he found that based on 2 things that, in my humble opinion, just are not there. I think, with all respect that Justice Kennedy is due, I think he went looking for this bias, and generally when you go looking for something, you tend to find it, whether it's there or not. He talked about one comment, and you can, I'll even play the comment right here, and then I'll give you the context. Here's the comment that was seized upon.
I would also like to reiterate what we said in the hearing, in the last meeting. Freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others.
That was the statement in context. It did not say that Mr. Phillips was despicable. It did not say that Christianity was despicable. It used the term despicable to describe the practice of using one's religious beliefs as a justification for doing harm to somebody else. Nevertheless, and conservatives are really good at this, where they look for this, they look for something like that, and then trumpet it as, oh, we're the real victims. We're refusing to serve people, but we're the real victims here. And I'm a little bit surprised that flew at the Supreme Court level, where with legal scholars who are trained to see through rhetorical arguments like that work on talk radio, but generally not in court. But at this time, it worked in court. And Justice Kennedy grabbed onto that and said, "You see, this tribunal was biased against religious beliefs, and therefore the whole thing was tainted, and it cast doubt on the fairness and impartiality of the tribunal." Another thing that he grabbed onto, which again I think is fantastic rhetoric, was around this time there were a couple of kind of activists, and they were trying to make the case for that these anti-discrimination laws are biased against religious people. And one of them was a guy named William Jack, and he would go into bakeries and he would ask for cakes to be baked that had messages on them that were that denigrated homosexuals. And when the bakeries would refuse to bake them, he would then file complaints against them with the Colorado uh, Civil Rights Commission and argue that he was being discriminated against on the basis of his religion. Now, to be clear, remember we talked about what is and what's not a protected class. Religion is a protected class. Uh, people with animosity toward homosexuals are not a protected class, and they're not synonymous. There are lots of religious people that don't hold that animosity. So the bakeries in question, for instance, one of them, he wanted a cake that had a picture of two grooms holding hands with a red X over it and the words homosexuality is a detestable sin. And that bakery, would not bake that cake. He filed a complaint, and the Colorado Civil Rights Commission found that the law had not been violated because that bakery wouldn't bake a cake with that message on it for anybody, and had a policy of not baking cakes with words on them that denigrated anybody. But if you're looking for evidence of anti-religious bias, and any evidence will do, which in my humble opinion is what happened, again, Justice Kennedy grabbed onto that and said, you see, here is also evidence of the Colorado Civil Rights Commission having a bias against Christians, and so therefore the whole thing is tainted, and we have to reverse the decision of the Colorado Civil Rights Commission. So he big picture is he rejected the argument that if it's against your religion to comply with anti-discrimination laws, that you're allowed to break them. And he also rejected the argument that, or didn't really address, and didn't adopt the argument that if you're expressing yourself artistically, then it violates your free speech right to have to comply with these laws. Both of those didn't fly. He just kind of threw a line to this one guy and said, this one time we're going to reverse this order because we kind of understand where you were coming from. Gay marriage was still illegal in Colorado at the time, and it seems like the tribunal that you were in front of was biased against you for feeling that way, and since it's biased, the whole thing is tainted. Justice Kennedy, it's a strange opinion, and Justice Kennedy quoted in the opinion, or referred to a decision where he wrote an opinion, decades ago, called Church of Lukumi Babulu I Inc. versus Hialeah. In that case, the city of Hialeah had passed an ordinance that banned animal sacrifices, which was a practice that was used by practitioners of the Santeria religion. It was directed right at them, and Justice Kennedy held that because that the lawmakers were motivated by anti-religious bias, then this whole law is tainted, it's invalid, and it can't be applied against members of the Santeria religion. And this isn't even a legislative body. This is an adjudicative tribunal, and so therefore that's even worse. One of the theories is that kind of toward the end of his career, he wanted to reaffirm how right he was when he decided the Church of Lukumi case. I don't know if I can really psychoanalyze him that way, but I know that he tried to write an opinion that made the Christians happy and made the homosexuals happy, and threw a line to this particular baker without overturning any earlier precedents like Piggy Park or O'Brien. And that was the majority opinion of the court. Now, let me tell you what a concurring opinion is for people who don't know. A concurring opinion is when one of the justices says, I agree with the result that you reached, although I have different reasons for why I agree with it, or I want to add something, or one of the reasons that you said I don't agree with that, but I still agree with your ultimate result. Justice Kagan is one of the justices that filed a concurring opinion, and she was joined by Justice Breyer. Now, she surprised me because she asked a lot of questions during oral argument about the artistic expression argument, where the bakery's lawyer argued, well, baking a cake isn't just preparing food, it's actually a work of art, it communicates something, and therefore it's speech, and therefore, if this law says that he has to bake a cake even if he'd rather not, then it is compelled speech, and that violates the First Amendment. So Justice Kagan asked, well, what about the chef who prepares the dinner for everybody? Is that chef engaged in speech, and can that chef refuse to cook for somebody who is who's having a gay wedding? And she said no, but wasn't really able to explain that distinction. Another question was, well, what about, forget about a wedding? What if it's a year later and they're celebrating their 1 year anniversary and they walk into a Michelin 3-star fancy restaurant and they say, we're here to celebrate our 1 year wedding anniversary. Can the chef at that restaurant, who believes that the meals that he's preparing are just works of art, can that chef say, well, I don't agree that you should be celebrating that, so I refuse to serve you? And the answer was no, but again, it's very difficult to explain why it would be one way and not the other. So I was a little bit surprised that she joined with Justice Kennedy's opinion, but she did write specially to explain that the William Jack cases didn't persuade her. She explained that he was asking for cakes that denigrated gay people and denigrated same-sex marriage, and he was and was refused. And she said that didn't violate the law because those bakers wouldn't have made those cakes for anybody, not just Mr. Jack, but they wouldn't bake them for anybody. So she said that the Colorado Civil Rights Commission was correct to find that there was no violation there, but she still bought into the argument that the despicable comment was enough to taint the whole proceeding. Um, and so she reads the majority opinion as consistent with that. She also opined that if the commission hadn't said that, if they hadn't said that those words that created the appearance of bias, then their ultimate decision would have been fine. It's just the fact that it was infected by some alleged bias that makes the whole thing tainted and had to be reversed. That was Justice Kagan and Justice Breyer. Justice Gorsuch, now he's our newest justice. He was the only justice appointed by President Trump, and he was joined by Justice Breyer, but I'm sorry, by Justice Alito. But Justice Gorsuch, he held that it would be fine with him if the bakery refuses to sell cakes that celebrate gay marriage, because he didn't think the issue was who was buying the cake. He thought the issue was what was going to be done with it. So in Justice Gorsuch's opinion, he felt that the fact that the mother called the next day and said, "Why wouldn't you sell the cake to my son?" And the answer was, "I wouldn't sell the cake to you either. I wouldn't sell a cake to anybody if I knew that it was going to be used in a gay wedding." That was enough for him to feel like the law wasn't violated. That he didn't refuse to sell a cake to Mr. Craig and Mr. Mullins because of who they were. He refused to sell it to them because of what they were going to do with the cake. And he also wouldn't sell the same cake to their mother, who was presumably straight. That was his argument. He also paid a little bit of lip service to what I think is a straw man argument. Straw man argument is when you say that somebody is making an argument that they're not really arguing. It's called setting up a straw man and knocking it down. Again, you see that a lot on talk radio, but it's generally frowned upon in the courts. He threw the straw man argument and said the state shouldn't be able to decide what is and what isn't offensive, and therefore on that basis, the law should not be enforced. It has nothing. This law has nothing to do with what is and what isn't offensive. It's about members of protected classes being able to use the same restaurants and auto mechanics and bakeries and hotels and motels that the rest of us are allowed to use. So I have a hard time agreeing with anything in Justice Gorsuch's opinion. It seemed to me like he was looking for the result that he wanted and then backing in some reasoning. It's not persuasive to me, this distinction between he wouldn't sell it to the mother, and so that makes it okay that he wouldn't sell it to Mr. Craig and Mr. Mullins. That would be like Woolworth's saying, well, we also won't sell a sandwich to a white person if we know that the white person's going to share a sandwich with an African American, and therefore it's okay to refuse to sell sandwiches to African Americans. It would be very obvious what was wrong with the logic in that argument, but but it was an argument that Justice Gorsuch and Justice Alito bought. 2 out of the 9 justices went with that. Justice Thomas, also joined by Justice Gorsuch, these are the only 2 justices, Thomas and Gorsuch, who bit on the compelled speech argument. Um, the, According to Justice Thomas, baking a cake does communicate that the baker approves of this wedding, and requiring him to do that is compelled speech. I'm not buying that, and I can't make a better argument than David Cole, the ACLU lawyer that argued this case, made. He argued, look, when a mother goes out and buys a birthday cake for her 4-year-old that says happy 4th birthday, nobody thinks that the baker is wishing the 4-year-old a happy birthday. Everyone understands it's the mother. If I buy my wife a card that says happy Valentine's Day, she doesn't think that Hallmark is wishing her a happy Valentine's Day. She understands that I'm wishing her a happy Valentine's Day with a card that somebody else wrote that didn't really have any interest in our marriage to one another. So I have a hard time with this argument that the baker baking a cake is the same thing as the baker participating somehow in the wedding. The other problem with that argument is, where do you draw that line? What about the rest of the food? What about the caterer? What about the band? What about, as Justice Kagan asked, the makeup artist, the hairdresser? Are they not also engaged in some kind of artistic expression? Would they have the ability to refuse to serve somebody based on their membership in a protected class? There are sandwich artists now. Could a sandwich artist say, I refuse to make you a sandwich because this sandwich is a work of art? I mean, there's no end to what could be swallowed up by that loophole, and it's an impossible line to draw. So that having been said, that was Justice Thomas and Justice Gorsuch, the only 2 that bit on this free speech argument. The dissent was written by Justice Ginsburg, and she was joined by Justice Sotomayor. Justice Ginsburg started by saying there's a lot that she agrees with in the majority opinion. She agrees that Piggy Park is still the law. She agrees that O'Brien is still the law. She agrees that religious objections, or the fact that you're engaged in some kind of artistic expression, does not give you a license to go ahead and violate anti-discrimination laws. She agreed with all of that. She called bull on the religious hostility rhetoric. Justice Ginsburg opinion talks about the Colorado Civil Rights Commission, and she says, listen, there were 4 decision-making tribunals that looked at this case. There was the Colorado Civil Rights Commission, there was the Colorado Civil Rights Division that made the initial probable cause determination. There was the administrative law judge. There was the Colorado Court of Appeals. So there are 4 different administrative tribunals that looked at this. And the argument that one of them had one person that made this despicable comment taints the whole thing doesn't work, because nobody alleges that there was any bias on the part of the Colorado Court of Appeals. They came to the same conclusion. Nobody alleges that there was any bias on the part of the administrative law judge. He came to the same conclusion. So I assume it was a he. It might have been a she. I didn't look up the name. But long story short, she says this is bull. This religious bias thing never happened. The court is looking for something that's not there and finding it, but this is not there. She also talked about the William Jack cases and went into more detail than anybody else did. The other opinions that mentioned Mr. Jack and his complaints, they didn't discuss exactly what he wanted, but she explained that one of the bakeries told him that they would happily bake him a cake in the shape of a Bible. They just wouldn't decorate it with hateful messages. Another one said the same thing. A third baker said he would bake the cakes, but he won't write any messages on them. You can write them yourself. The commission found that there was no discrimination, and they noted that those bakers didn't have any anti-religious bias, that they regularly baked cakes for Christians with Christian symbols on them or cakes that were shaped like Bibles. And they regularly denied other customers' requests for cakes with texts on them that demeaned anybody. They just didn't sell cakes with demeaning messages on them for anyone. So she called BS on the William Jack argument too, and said that neither of those things are evidence of anti-religious hostility on the part of the Colorado Civil Rights Commission. It's just not there, and that not being there, she feels as though there's no reason to overturn these other precedents. That Piggy Park and O'Brien are still the law, and that the Masterpiece Cakeshop did not really raise any particular ground for why those precedents should be overturned. So the takeaways from this, and actually before I get that, I want to point out, let's go back to the Colorado anti-discrimination law, or the Colorado Anti-Discrimination Act. If you look at the text of this, it first off, it does create an exception for if you look toward the bottom, it does the bottom of subsection 1. It creates an exception for a church, a synagogue, a mosque, or other place that is principally used for religious purposes. So the Colorado Anti-Discrimination Act itself recognizes the right of religious people to discriminate as long as it's a church or a synagogue or a mosque, not a place of a public accommodation that's a business. So there's a couple of ways that Mr. Phillips could have continued to discriminate legally. One of them is he could have, as part of his retail establishment, stopped selling wedding cakes out of that, and become, started a nonprofit or started a church called the Church of Cake, a nonprofit organization that provides cakes to religious ceremonies, including religious weddings or something like that. And then it would have fallen within this exception of a church, synagogue, mosque, or other place that's principally used for religious purposes, and nobody would have given him a hard time about only providing cakes to people who were engaged in religious ceremonies that were consistent with his own religion. But he didn't do that. Another thing that he could have done is not been a public accommodation. He could have been like a portrait painter who, I suppose there are those guys that sit outside and do caricatures of people. Those might be public accommodations, but somebody who's a famous painter or a famous photographer that does not have a retail shop, that only just takes appointments and only paints the portraits of the people who they want to paint portraits of, those people are allowed to discriminate. So Mr. Phillips could have not sold the cakes out of his retail shop and only sold cupcakes, wedding cakes, shower cakes, whatever out of his retail shop. And then if you want a wedding cake, if you went in there and asked for a wedding cake, they'd say, "We don't sell wedding cakes, but you can call this guy Jack Phillips, and if he likes you, and he might not like you, but if he does like you, maybe he'll bake you a cake if you talk him into it." That would have been legal. He could have done that, but no, he wanted to have a retail establishment that's open to the public and look gay people right in the eye and tell them, "We don't bake cakes for people like you, but we bake cakes for everybody else." And that's why it violated the Colorado Anti-Discrimination Act. But this Colorado Anti-Discrimination Act is not forcing anybody. You hear that rhetoric a lot. Force them to bake. Nobody held a knife to his throat and forced him to bake a wedding cake for anybody. The law just holds that if you're selling them to the general public, you can't refuse to sell one to somebody based on their membership in a protected class. But if you want to be a church, you can do that and discriminate. If you want to not be a public accommodation, you can discriminate. It's just that you can't be a public accommodation and discriminate, and that's what he was doing. So back to the takeaways from the opinion. The most important thing to remember is the Supreme Court had an opportunity to overturn existing precedents. They did not do that. People like me and a lot of other civil rights lawyers were biting their nails for months, afraid that that might happen. And Justice Thomas and Justice Gorsuch and Justice Alito, they would have done it, but they didn't have 5 votes to do it. So Piggy Park is still the law. Your religious beliefs don't give you the right to break anti-discrimination laws or any laws, really. And O'Brien is still the law. The fact that you feel that you're expressing yourself by breaking the law doesn't mean that you're allowed to break it. As far as what happens to the Masterpiece Cake Shop, it's unclear what happens now. When the Supreme Court overturns a decision of a lower tribunal, the case isn't over. They just send the case back down to that tribunal and say, you did it wrong. You still have another chance to do it right, but you did it wrong. What the order that you've issued can't stand. So this case will ultimately land back in front of the Colorado Civil Rights Commission, and they'll have to decide what to do. They could drop the case. They could reverse themselves. They could impanel somebody else. I don't know if the person who made the despicable comment is still on it, but they could hear the case all over again or refer it to administrative law judge all over again. I'm not sure what they're going to do, but the case isn't over. It's still possible for Masterpiece Cake Shop to lose in the end. They did just kind of win this one battle on this one very, very narrow ground that no one else is going to be able to use except for that one bakery. Um, but to be clear, the case is not over yet in terms of the parties are still litigating it. So we really don't know what the ultimate outcome is going to be. It very well may be that the Colorado Civil Rights Commission just issues the same order again, except without infecting it with any kind of anti-religious bias that anyone can seize upon as a way to try to invalidate their order. There's a couple of other cases coming up the pipeline. There's an Arizona case involving a calligraphy shop that refused to make gay wedding invitations. That's a lot closer to speech than baking a cake. I think it was a little bit ridiculous to argue that baking a cake is baking food, but if you put enough designs and curlicues on it, then it becomes speech. It's difficult to draw that line. I suppose you could put text on it, but you can put text on anything. I guess you could write something on a T-bone steak with a squeezy ketchup bottle with a pinhole. That doesn't mean that cooking a steak is speech. But calligraphy is a lot closer to speech because it's actually making words. The Arizona Intermediate Appellate Court held that they had to make the invitations, that it does violate the law to refuse to do that because they're just doing lettering. They're not really saying anything. And again, when you get a wedding invitation, nobody thinks that the calligrapher is inviting you to a wedding. Everybody thinks that the married couple's inviting you to the wedding. They just hired somebody to do the lettering for them. That one's in front of the Arizona Supreme Court, and that one might end up in front of the Supreme Court again one day. There's another case in California where a court tried to split the baby and hold that a bakery that has already baked a cake and put it in the window has put that cake into the stream of commerce, and they can't refuse to sell it to anybody based on um, their uh, their membership in a protected class. But the bakery can refuse to make a custom cake. It can refuse to bake a new one. To me, that sounds a lot like Woolworth saying you can buy the sandwiches that are already made, but we don't have to make you a new sandwich. And I think maybe even the Masterpiece Cake Shop cake might have done away with some of that rationale because it really hung its hat on the free speech rationale that the Supreme Court rejected in the Masterpiece Cake Shop case. But those ones are coming along the way. I think that there's still an appetite to challenge the validity of these laws that forbid discrimination against people based on their sexual orientation. There's just still enough people in the country who just aren't ready for that. They're not used to that, and they don't want to start now, and they want to push back against any law that requires them to change the way that they've been doing things for as long as they've been doing them. And they're going to keep pushing this. I hope that the Supreme Court, however, has lost its appetite for re-examining the Piggy Park decision and the O'Brien decision, and that they don't take the opportunity to look at this again and put those two holdings in jeopardy again, because I really think that Piggy Park and O'Brien took really difficult issues and reached the right result with them in holding that if we recognize this loophole, that you can break whatever laws you like so long as you say that your religious beliefs require you to do it, or so long as you feel like you're expressing yourself by doing it. The size of that loophole is so big that you could pretty much break anyone could break pretty much any law they want, and they understood that we can't create an exception that's that big. So the bottom line is that nothing has really changed. The Supreme Court just threw a line to this one particular bakery without making any change in the law, and they did so on grounds that strike me as a little bit contrived. The alleged hostility that they think they saw in the commission's deliberations just wasn't there. But the bottom line is that that rationale is only really going to be able to ever be used by that one bakery that one time. No one else is going to be able to use it. Everybody else is still stuck with the piggy park rationale that if no matter what your religious beliefs are, if there is a law that forbids you as the owner of a public accommodation from refusing to serve somebody, you do have to comply with that law. So as things stand, both of these questions were answered long ago. The answer was no then. The court reaffirmed that the answer is still no. And don't believe when anybody tells you, if they try to tell you that the Supreme Court says that it's legal to discriminate now because as long as it's consistent with your religious beliefs, that didn't happen. And I'm happy to have spent all this time to make this video as sort of a public education to help people understand the the Masterpiece Cake Shop decision, what it meant, what it didn't meant, and what happens next. So thank you very much for listening all to the end of this little video lecture. I hope it was informative, and everybody, peace.